allow Robin to go ahead and ask any question you may have.
Yeah, the main question, well, I have two questions, but the main question I wanted to ask today was relating to patent law.
Mm.
And if you knew how much difference there was protection, I mean, I know that there is much greater protection in filing the patent itself, but I don't have the money in order to be able to file the patent and go through all the um, what is it called?
The registration process.
Well, the filings, and if anybody objects because of prior art,
Right.
um, not contest, but
Okay.
so if what the difference is between that and just doing a provisional patent, and will a provisional patent have sort of the same enforceability as having a full patent without going through the full patent process, or is it really just me putting out what my IP is without any protections at all?
Mm. A few issues. First, I am not a patent attorney.
Yeah.
A patent attorney needs a specialized lawyer license. They must pass an additional hurdle and an additional bar exam called the patent bar exam. They must have an engineering or a bio or a mechanical background. So there are certain credentials to do the patent prosecution, which is the application process for a patent with the United States Patent and Trademark Office. Okay, and you're exactly right. There's two different types of applications: the provisional, and I believe the other one is a utility application. And there are different requirements. But I would speak with a patent attorney who does the application, and I can get a referral for you. We could speak off camera. But I will say this: I do other intellectual property, such as copyright and trademark.
Right.
There are three forms of intellectual property: copyrights, trademarks, and patents. Patent applies to anything that occurs outside of nature, a process, an invention. If you are adding something to the natural cause of something, then it could be protected by a patent. Trademark protects your brand, your mark that identifies your business when you are placing your product or services in commerce. Copyright protects your creative ideas expressed in a tangible medium. Now, there's somewhat of an overlap between those three areas of intellectual property. Maybe a piece of work can also be protected by copyright. And that patent, well, maybe the most valuable piece of intellectual property will be your brand. Okay. And you can, on all these pieces, you can have licenses. All right. But what I'm saying is there's an overlap. Without getting into more specifics of your particular work, we really don't know if patent is the exclusive form of intellectual property protection.
Well, I mean, I basically deal in all three.
Exactly.
As far as the patent goes, I know that you're not a patent attorney. I was just asking sort of a generalized question based on your knowledge. And also, as far as the trademark, if I've incorporated using my company name, and that really isn't effective unless I have the trademark to go along with it, or is there a certain amount of legal weight that goes with the incorporation?
There is a certain amount of legal weight that goes with incorporating and having a business name. You're taking as professional. There's an aura of professionalism when you conduct business. You can be identified by your business name. So there are some benefits to having a business name, not to mention the legal protections of the corporate shield. All right, whether you're an LLC or a corporation, there's a legal protection, and that's probably the most valuable benefit, to separate your personal assets from your business assets from any creditors or liability.
I'm currently just an LLC.
Right. Okay. But is it necessary to have a trademark? As long as you put your mark, there are common law rights. As long as you're using your mark in commerce, you are obtaining common law trademark rights in state court if you were to ever bring an action for infringing on your mark in that locale. Okay, common law rights are at a smaller locale. Okay. If you're conducting business across state lines on the internet, you really want to have federal registration.
Just
okay. Yes, federal registration with the United States Patent and Trademark Office. You want to put the public on notice. It puts your rights across the nation. Okay, common law rights are smaller, locale, and they're weaker. They're more difficult to enforce. You really don't have anything on the public record providing the public on notice that you are using this mark in commerce. So you need the registration in order, and when you have federal registration, it allows you to get into federal court, which is at times a better venue depending on the dispute. And also it gives you some special remedies, such as treble damages and injunctive relief. Those are powerful legal remedies. Okay.
Right. I mean, I incorporated in the state of California, so I need to have the trademark in order to be able to have it as national actionable.
Yeah.
Should I get infringed? I mean, there are a lot of people that are calling them, well, my brand and my trademark is the 21st Century Da Vinci, and there are a number of people calling themselves that. But as far as I could tell, and I did due diligence to find out if anybody else had incorporated as that, and I did not find anybody. So it's a question of, is it going, if I get infringed and on the East Coast, would that be sufficient in order to have injunctive relief? And you're saying until I've trademarked on the federal level, that's not the case.
You bring up some good points, and you mentioned some good things to do. Due diligence, very important. Your trademark search. You identified some businesses that may have a prior claim to this mark. So you may have, in fact, discovered some businesses that may be asserting their rights against you because they are first in time. You may also want to check the registry, the trademark registry, to see what is registered. Okay, because they may be doing business just like you without registration. So their marks are only common law marks based on a smaller locale and weaker. So you could beat them. There is a competition here. This is business. So you could beat them to registering that mark and get stronger rights on a national scale. Okay. You do have to also look at the markets, the industries. Maybe the test for trademark infringement is in the eyes of the consumer. Is there a likelihood of confusion amongst the brands, the marks? Because trademark is really meant to protect the consuming public so they can make quick buying decisions based on quality. Okay. And so you want to do your due diligence. You want to take it even further and search the trademark registry. They have the there is a primary and a secondary registry. I would search them both. Okay. Secondary is those that are have not obtained primary trademark rights. They're still acquiring it through creating their market recognition. Many times it deals with some brands that aren't so unique. So you have to develop brand recognition.
As far as I know, I'm the only person who's using that as a corporate entity.
Okay, but
You know,
you
I mean, the phrase 21st century Da Vinci has been bandied about quite a lot over the last 20 years because they call anybody who's basically captain of industry a 21st century Da Vinci, you know, like Elon Musk.
I see
You know,
what you're saying.
they call him a 21st century Da Vinci when he doesn't invent anything.
Mm,
The only thing he's invented was PayPal.
mhm.
Everything else is buying and subsuming other people's rights and properties, and then you know reincorporating with his name. So,
You bring up some really good points again. Allow me to just refill my coffee real quick.
sure.
So, yeah, Robin, to go back to your question. Can you repeat that? Can you refresh my recollection real quick?
Well, the phrase 21st century Da Vinci has been made for you know a number of quote unquote captains of industry if they have more than one business, but it's a moniker that really doesn't has no weight legally. It's just you know what people are called. But I was basically codifying that into my
Well, you bring up a good point, Robin. And you basically identified the issue. It is now a phrase that potentially, based on how the court views it, potentially may have experienced what we call genericide. Okay, so now the term has become generic and
right.
has lost its unique value. So it may not be subject to trademark protection because it's generic. The key to trademark protection is unique. Okay, the more unique, and there's levels to this. There's different degrees of strength. There's a strong mark, something very unique, a made up name. Okay, but that made up name, once it becomes very popular, it can actually backfire and become generic. For example, Xerox.
Right.
Xerox was unique, but it has become such a commonplace name or term that it has suffered from genericide and has lost its value. Trademark value is based on uniqueness. So you're bringing up some issues with your mark. Okay. And if you do want to go forward with using this term, remember the strength lies in unique. So it's probably not more the name, but maybe if you bring that name into a unique type font or a logo design, now you can still protect it. Okay. But it's based on the unique font, the unique
I
layout.
have a logo that I basically produced.
Well, the logo can be subject to protection, trademark protection. That's unique. But the term itself, depending on your industry, it seems generic. Okay. It's too generic and it may be too descriptive, so to speak. All right. You can't use the same term to describe the product. For example, you can't use apple on an apple to sell an apple.
Right.
But you could use an apple on a computer.
Right. Well, that came up when Apple first came out. The Beatles basically sued for infringement, and it was ruled that it was two separate industries and therefore was not infringing.
Yeah. It's developed what they call secondary meaning. Once you take a generic term and you identify it to you attach it to your brand, it has developed secondary meaning. And once that's
how I'm distinguishing it is calling myself the 21st century Da Vinci as opposed to the generic.
Well, I think the better argument to make, because you will have to make an argument to a trademark officer. Okay. Right. I think the better argument is to make is based on your industry. I don't know what your industry is, but it's so unique to your one specific industry that only you can be identified with that
Well,
within your industry.
the whole idea is that 21st Century Da Vinci is an umbrella corporation for my other corporations or my other businesses right now. And I have 4 or 5 of them in different areas. I have art, I have technology, I have writing. So those 3 are the primary industries that fall under that umbrella. I currently have the tech project I'm working on, and I currently have the literary imprint. I have those basically subsumed under the 21st Century Da Vinci LLC.
Mm-hmm. Mm-hmm. I just think in terms of protecting a trademark, it may be difficult to get that registered. However, your logo with the name, yes, that can be registered. Okay. Yeah.
All right,
All right.
I'll let you go on to other people.
Well, we had Anthony on, but he just signed off. He might sign back on.
Was Anthony the one that was coughing a lot?
Possibly.
Okay. Yeah, I mean, I've only been on a couple of times, and it was only one other person besides me.
Yeah,
And
no problem. Yeah,
I generally listen in because there may be something that, someone else says that may be pertinent.
absolutely. That's why we like to bring the group together and help each other person who signs on. I'm sure what we discussed also helped Anthony as well. I'm familiar with Anthony's situation, so I'm sure he gained a lot. And we're also going live too. I don't know if anyone is signed on live. Still always getting used to the technology. But we do have to let you know that there is no confidentiality. There is no attorney-client privilege here. And if we want to get more into specifics, it's best to reach out to an attorney for a confidential consultation.
I'm looking forward to being able to afford to hire you.
Yeah. Well, keep tapping on here. This is, a good source. This will help you stay accountable.
Yeah.
And that's what we're here for. If I can, help you in any direction, as far as long as it's general and we don't get specific to protect confidentiality, and I'm happy to be of service.
Once I've gotten some funding, I'll be flipping the LLC into a subchapter C, at which point I'll be needing your assistance.
Okay. When I hear subchapter C and subchapter S, and when I hear about corporations are business legal entities which are more on a grand scale. So you're right. That is better for attracting investors. They're more flexible. You can create shareholder agreements. You can have different taxation elections. It's more for vast capital. Okay. But,
Right.
I tend to defer to ease. Corporations are difficult in terms of their formalities. You have more responsibilities, more reporting requirements. Okay. There's more exposure. You could be bringing on more investors. So there's more legal formality requirements, more accountability. Okay. Whereas in LLC, and you probably have heard the pitch before, but there is truth to it. An LLC is a more flexible business entity. It has the ease of a partnership in terms of less formalities, okay? Less restrictiveness in operating.
I originally filed the LLC because I had someone who, quote unquote, had an investor to invest in my tech project. And then when he claimed he didn't like to, get involved with a lot of legalese in his NDA, and so he sends me his NDA, and I have enough knowledge of the law to be able to read it. And one of the things that I read was I could get money, but I'd basically surrender my IP to him.
Mm.
So
Well, you
it's
did
like,
it. You did a good job by reading the document.
right. So as soon as I saw that, I was like, no, I'm not even going to contact you again.
Yes. Some
I
people,
just,
some people are not quite informed as you are. And there's a few policies that I like to keep in mind when presenting with those type of situations is one, read the full document. RTFD, always read the full document. There might be one provision at the end that impacts the provision in the beginning. You can't read it separately. You have to read the full document. Okay. And also, when it comes down to signing an agreement, you should have it reviewed by an attorney. And I'm not just saying that because I'm an attorney, but because when you sign a contract, that is the time when legal rights are being transferred. And that is the time you need to be informed. Okay. Because some people are just not as informed as you were, and they may have signed away legal rights, valuable rights without knowing. And so that's why it's always best to at least consult with an attorney before signing any agreement.
if he had been less upfront about it in the document, I might have missed it if it was one of the writers. But it was pretty much, form front, so that it was easily recognizable the scam he was pulling on me. Yes, if I had been a different person, if I hadn't had certain amount of legal knowledge, yes, I probably would have signed it, and I probably would have signed away my rights, and therefore. And he didn't really have someone who was a backer. I mean, he had someone who was a backer, but I then found out that in the state of California, it's illegal to be a broker in that case.
Right.
So it would have been, I could have signed it and it still wouldn't have been a legal document because of that. But
Well,
I didn't sign it, so.
Well, we are at the 30-minute mark, and I just want to say thank you for signing on, and please keep coming back. This is a great resource, and it's just a great source to stay accountable, no matter what legal issues you're dealing with. This is our opportunity to be of service. So I want to thank you, and I want to say take care and take action, and have a good rest of your week.
Thank you for all your information.
Thank you.